Hello, my name is Wally Urban. I'm a lawyer with Lewis Thomason. Lewis Thomason is a full-service law firm with offices in Nashville, Memphis, and right here in Knoxville. Today, we're going to talk a little bit about OSHA, which is the Occupational Safety and Health Act, as well as the Occupational Safety and Health Administration. Now, you may be asking yourself, hopefully not, but you might be, what is OSHA? And what is it, or what are they? The Occupational Safety and Health Act is an act that was passed by Congress in 1970 to ensure worker health and safety. The goal was to ensure that all employers are providing their employees with a workplace that is free from recognized hazards that are likely to cause death or serious bodily injury. OSHA itself, in terms of the agency, is the federal agency that's tasked with the purpose of fulfilling all of the requirements of the act to ensure worker safety. They set and enforce safety standards. They provide training, outreach, education, and assistance to employers to help them provide a safe and healthy workplace. They also, through a separate arm called the National Institute of Occupational Safety and Health, serve as a research arm for not only OSHA, but the Department of Labor, to make sure that all of the safety standards that are in effect are applicable and up to date, as well as to determine whether or not to add any additional standards. Now, who does it apply to? You may say, well, does it apply to me? If you're in business and you're a member of the Knoxville Chamber of Commerce, probably does. OSHA applies to all private sector employers and some public employers. It applies throughout the 50 states, as well as the District of Columbia, and certain territories of the United States. Primarily, again, it is administered through federal OSHA. However, there are several states that operate their own OSHA plans. Federal OSHA allows or is entitled to delegate that responsibility for ensuring worker safety to the individual states, provided that they enforce all of the rules and regulations at least as strictly as the federal OSHA does. Tennessee is one of those states, one of 22, that is able to operate its own state plan through the Tennessee Department of Labor and Workforce Development. So in terms of how they go about doing it, these standards, they're organized generally into four separate categories. One is a general industry category that would be anything from retail to office environments, hospitality industries. Construction industry is the second. Obviously, that's going to apply to contractors, heavy highway construction, some industrial processing plants, depending on the type of work. The agricultural industry, farming generally, as well as maritime, meaning anything that is operating on water. Now, although those are separated into the two specific industries, it doesn't mean that you're locked into one. It's based on the type of work. So, for instance, if you had a contractor, there's going to be a portion of the contractor's business and some of their employees that may be operating in the office environment. In that sense, they would be subject to the general duty standards. The gentlemen or the ladies who are working in the field, actually building a project, are going to be subject to the actual construction standards because that's the type of work that they're performing. So it's important to know that what's going to apply to your specific business. In terms of examples, generally, there's not going to be a crossover in terms of if I'm in the general industry, and you're not performing construction work, you're not going to be subject to those construction standards. Same way with agriculture. If you're in the office environment, in most cases, you're not going to be subject to the agricultural standards. That doesn't mean that a single standard is not going to appear in all four of those categories. It just means in general, if you're going to be performing a certain type of work or a certain type of service, you're only going to fall in one, if not, and very rarely two of those. Some of the examples of the standards that you may know about are lockout, tagout procedures, falls, trips, and protections against those falls and trips. Some struck by standards or standards intended to prevent an employee from being struck by something, personal protective equipment, ensuring that workers have access to personal protective equipment and actually use it, as well as machine guarding. With the individual state programs, one thing you see a lot of are special emphasis programs, which are geared to try and address some of the standards that appear most often, or some of the standards that are violated most often, or at least most recently by employers throughout the state. Here in Tennessee, there's a number of separate special emphasis programs that are undertaken by the Tennessee Department of Labor to address amputations, carbon monoxide, poisoning, combustible dust, and exposure to that, falls, trips, noise, lead, and cave-ins, among several other programs. Now, what is the purpose of those programs? Again, those are generally the type of violations of standards that result in death or serious bodily injury, or that OSHA is trying to make a point of. We see a lot of these type of violations. These are the programs we're going to focus on. And when they're doing programmed or random inspections, those are generally going to be the industries, or at least the types of employers that could have some exposure to any of these types of hazards. Those are the industries that they're going to focus on in terms of a random inspection. Now, in addition to all of the specific standards that go not only for those special emphasis programs, but as an industry as a whole, there is always what is called the general duty clause. And this is kind of the catch-all standard for Tosha. If in general, you can only be cited for the violation of a standard if there's an actual standard that applies to the particular action or hazard that exists on your work site. However, there is this overarching duty that every employer is required to furnish a place of employment that is free from recognized hazards that are likely to cause death or serious bodily harm. In that case, we're only dealing with serious violations. There has to be some type of exposure to death or serious bodily harm in order to try and cite a particular employer under this general duty clause. But it is important to understand that you can be cited under that clause, even though you technically didn't violate a standard. If an employee, that you're generally only going to see this if an employee is actually injured, as opposed to just having a near miss or a near hit, depending on your point of view. But it's just good to know that it's out there. And again, in addition to accidents, there's a number of different ways that OSHA can arrive on your site. There's certainly the random inspections that we've alluded to here briefly. There's also a complaint process that whether it be your own employees or somebody who's passing by, some third party, anybody can make a report of a complaint to OSHA that might initiate an inspection. And just because you're inspected and just because there might be a complaint that OSHA issues doesn't mean that you're out of luck. There are several defenses that are available to any type of workplace standard or citation that's alleging a violation of any of these OSHA standards. One is infeasibility, meaning it was impossible to comply. Unpreventable employee misconduct, meaning the employee had been trained on certain procedures on what the safety rules were. They just ignored them for whatever reason. There could be a greater hazard, meaning that by complying with the standard, I was actually exposing my employees to a greater hazard than what they would have been had I not tried to comply with that standard. And finally, vagueness. You have to have a reasonable idea of what a standard requires. And there are several of those standards that are in place that require broad actions, but don't really give you any idea of how to actually comply with that. To actually prove these, you're going to have to go through a formal defense. But how do you avoid Tosha and OSHA issues? This is really what we want to get down to. Is first of all preparation. Know the standards that are applicable to your workplace. If you're in the general industry classification, know which ones of those standards are actually going to apply to your business. Review your current policies and procedures. This can either be done with your internal HR staff or with any attorney that practices in your field. Develop a written safety plan. This is a big one in terms of not only ensuring that you and your employees are aware of what you need to do to maintain a safe working environment, but it's also important if you ever do have an issue on down the road, whether it be with OSHA or Tosha, because it's something that you can present to them so that they can see you were actually doing things the right way, or at least we're trying to. Because if it comes down to where you've been cited for a particular violation, in their eyes, instead of actually taking it through a formal complaint, they will work with you in some instances to try and mitigate either the penalty amount or the classification of that citation. Next, make sure your employees are trained appropriately and regularly on the work or the specific type of work that they're doing. Provide all necessary personal protective equipment. And one of the most important is documenting enforcement of safe work rules. Meaning, if you have a written safety plan and you have an employee who violates it, make sure you're actually keeping up with that. Make sure you have a progressive discipline procedure in place, so that the more, if an employee breaks one type of work rule the first time, there's a certain level of punishment, and make sure that it progresses up through termination if necessary, depending on the severity and the particular violation. And finally, consider consultative services. Consultative services is a group within Tosha that it's a voluntary program that works with employers to achieve a safe and helpful workplace. Again, this is a free service provided by Tosha. And the way they do that is they provide inspectors that go into your facility, and instead of looking for individual citations to be able to, or any violations to be able to write a citation that you've be subject to, it's almost a free pass. They go in, they look at your facility, they identify any particular hazards that might be posing a problem that would otherwise result in a citation. Only because you are asking them to come in, it's a free pass day. As long as you are willing to fix any issues that they find, they're not going to cite you for it, and you generally have a free pass for a year of not being subject to any sort of random inspection. Now, we've talked about be prepared, but what if? What if something happens? Accidents do occur. If necessary, if there is serious injury or death, be sure to call 911 immediately, first and foremost. Because at the end of the day, what you're trying to do is providing a safe and healthy workplace. And the best thing for you at that moment is to make sure that the employee who is injured has the best care that they can get in a timely manner. So make sure you're dialing 911 first. Second, contact your safety coordinator, your HR department, or your lawyer, and generally all three for that purpose. That way they can go ahead and start documenting to the extent necessary. You can get a lawyer or your safety coordinator or your HR department involved to be able to prepare for what is certain to be an inspection, either immediately that day or within the following day, to be able to look at the site. And there's some actions that they'll want to take to not only preserve the site where the employee was injured, but also to monitor and maintain the remainder of the site and take some actions there. Finally, if you receive a citation, again, notify the safety and HR departments within your company as well as your attorney. There are very short deadlines that you're going to have to need to meet in terms of filing a notice of contest if you disagree with the citation. You also have the ability, at least at the state level with Tosha, they are very willing to enter into an informal settlement conference to be able to discuss in, not a confidential setting like you would in a mediation, but definitely in an open environment where they're willing to discuss the allegations that are specific to the event that gave rise to the citation, as well as some potential resolutions that might be available without having to go forward with a formal enforcement proceeding. But if you're not able to do that, it's also important to get everybody on board early on so you can prepare for the formal enforcement proceeding and hopefully get the resolved to your satisfaction. Now, I appreciated the opportunity to talk to you today about just kind of the basics of OSHA and Tosha. And if you have any questions, you can feel free to give us a contact, either me personally through a phone call or an email, or at any one of our 3 offices here in Tennessee.